Welcome, everyone, to the Federal Bar Association Key Tam sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Committee Chair of the Key Tam section, here with Tejinder Singh, who's a partner at Sparacino PLLC. Tejinder, good morning.
Hello, Scott.
So, Tejinder, it's been a busy time recently for the False Claims Act. Let's start with U.S. ex rel. Rosales. This is a case out of the Fourth Circuit. It's an opinion. It offers some rules that help to resolve first-to-file disputes on the procedural side, of course, and, interestingly enough, on the substantive side. Tell us more.
Yeah, so this is a pretty thorough opinion addressing the first to file bar, and it reaches a couple of interesting holdings. First, the Fourth Circuit notes that it is in the minority of circuits that treat the first to file bar as jurisdictional, which means courts have to raise it on their own initiative, I guess, and have to dismiss without prejudice. It notes that its position is in the minority and may be wrong, but it finds itself bound by prior panel precedent. Um, then it goes on to describe how the rule should be applied and says you have to apply it claim by claim and defendant by defendant rather than treating an entire complaint as barred if any part overlaps with a pending action. So it calls for somewhat granular analysis. And it says that when you do that, you analyze the most recent properly filed complaint, including amendments that add new claims or defendants. And then it goes on to say, when you do this analysis, you have to do it in a way that is sensitive to the facts of the case and particularly attentive to whether the first complaint might have put the government on notice of the fraud. And so the court adopts a sort of totality of the circumstances test and says, look, the mere fact that you've added new defendants to your second complaint doesn't mean the bar doesn't apply. And the mere fact that the defendants were the same doesn't mean it does apply. You're going to do this more granular analysis. And this is the type of analysis that I think most courts are trying to do here. One reason why I think it's a little bit troublesome is that it does call for courts to speculate a little bit about what the government's reactions might be to a particular complaint. And I think that that can be a somewhat fraught enterprise. But nevertheless, it is the analysis that I think most courts are adopting in this area. And so the Fourth Circuit sets down some really clear rules here that I think will be easy enough for people to follow in raising and defending these challenges in the future.
Let's swing over to the Fifth Circuit, U.S. ex rel. Doe versus Planned Parenthood. This is an unusual one Tejinder. It's an unpublished opinion, written per curiam, yet it seems to announce a whole new doctrine of immunity for attorneys who act as advocates during litigation. The court then applies this new immunity to actions that might otherwise be unlawful under the False Claims Act, and the defendants are off the hook. Is that right?
No. I'll summarize what happened in this case a little bit. This is a case against Planned Parenthood. And so what happened is the relator here made some recorded conversations with Planned Parenthood on the Gulf Coast about fetal tissue donations for research. In response, Louisiana and Texas sought to terminate some of the Planned Parenthood affiliates in the area from the Medicaid programs. And then Planned Parenthood's legal department, their in-house lawyers, gave advice to the affiliates about how to deal with that process. Federal courts enjoined the states from terminating the affiliates, and then one of those injunctions was reversed. The FCA complaint is that the affiliates violated the False Claims Act vis-a-vis certain Medicaid claims that were presented during the period of the injunctions, and also that they conspired with Planned Parenthood to violate the False Claims Act and the state analogs. And what the Fifth Circuit says here is it says, we're going to decide that basically anything the Planned Parenthood lawyers did in their role as advocates is subject to absolute immunity of the type previously recognized for prosecutors or attorneys of state agencies. We're going to give that same immunity to Planned Parenthood's private in-house lawyers. And then we're going to say that because the lawyers are absolutely immune, their principal cannot be held liable on a theory of respondeat superior either. And so there can be no False Claims Act case based on the actions of lawyers acting as advocates. This ruling is, to the best of my knowledge, so it's an unprecedented decision, unpublished, but it is, to the best of my knowledge, the first time absolute immunity has been extended to private attorneys. Um, and although I think the case against Planned Parenthood might have been a bad one to begin with, this ruling creates all sorts of potential for really weird outcomes and mischief.
We're going to watch this one for sure. Let's move to U.S. Exrel Wheeler versus Acadia Healthcare. Back to the Fourth Circuit. Tejinder, you argued for the relators in the case. It's a reverse FCA case about an issue that we have discussed in our September 2024 episode in a case called Miller from the Second Circuit. When is a defendant's obligation to pay money to the government too contingent to be actionable under the reverse FCA? Tejinder?
Yeah, so this was not only a reverse False Claims Act case, it also had false claims. It arises under violations relating to opioid treatment programs. And so for people who are interested in the other issues, materiality, Rule 9b, there's good analysis in the rest of the opinion too. But as far as the reverse FCA piece of it goes, there was a corporate integrity agreement imposed on Acadia, and it required Acadia to do several things, two of which are relevant here. First was to provide certain training to its employees and to publicize that training internally. And second, to report on potential violations. And what the relator alleged here is she alleged, well, I worked there and I never got the training, and I don't know about anyone else who did either. And also, I reported internally all of these violations, and Acadia never said a peep to the government as it was required to do under the CIA. And the CIA specified that any violations of those two requirements would accrue stipulated monetary penalties of $2,500 a day, beginning on the day of the violation. And so the argument was, by not reporting these violations, Acadia had violated the Reverse False Claims Act to the tune of $2,500 a day in damages. There is a debate among courts about when obligations count as obligations under the reverse FCA. And broadly speaking, courts say that if the government has to take discretionary action before an amount is due, then it's not a sufficiently concrete obligation. What the court holds here is that because these penalties become effective on the day of the violation, and the only thing the government has to do is assert its right to collect, they are not the sort of wishy-washy contingent obligations that have been held not to give rise to FCA liability in the past.
Finally, Tejinder, let's turn to the First Circuit, U.S. versus Regeneron Pharmaceuticals. This is the latest battle over the causation standard that applied when the False Claims Act is said to result from a violation of the anti-kickback statute. This is under the 2010 amendments to the False Claims Act. The panel here says that the illegal kickback must be proved by a but-for causation standard, and then goes on to say that that means it must be proved on a claim-by-claim basis. This looks to be a tall order, but this is not the first court to rule this way. Tejinder, tell us about it.
Yeah, so the issue is that in the 2010 amendments to the anti-kickback statute, Congress specified that any claim resulting from a kickback is per se an actionable false claim. Prior to that, anti-kickback statute violations had been pursued under the FCA using a false certification theory of liability. And I think part of what Congress was trying to do was to make it super duper clear that, whatever the merits of certification-based theories of liability, AKS violations were going to give rise to FCA liability too. What happened in this case is also what's happened in the Eighth Circuit and the Sixth Circuit. Courts have looked at that language resulting from and says it requires but for causation. The government and relators have taken a broader view of what the language was intended to do and said, no, if the claims were in any way tainted by kickbacks, if kickbacks were being paid contemporaneously with the claims, for example, or there was some causal nexus between them, that's enough. You don't need but for causation. And the Third Circuit actually adopted that view in a case called Greenfield. But subsequent to that, courts taking, I think, a more strictly textualist view of the statute have said resulting from means but for causation. The First Circuit joins that consensus here. Importantly, though, like the Eighth Circuit, it leaves open the alternative certification-based pathway and says you don't need but for causation in those cases, you just need materiality, as the Supreme Court explained in Escobar.
So what's the advice that you give to Tejinder in terms of pleading where you have a anti-kickback theory? What should a relator be thinking about in pleading his or her claims?
I think I would always plead it both ways if possible. That is, I would plead that but for the kickbacks, the claims would not have been presented. And I would plead that in any event, certifications of compliance with the anti-kickback statute rendered the claims materially false. Of course, that depends on you having some facts to back up those assertions. I think it's often going to be a fair inference that kickbacks cause payments. You can prove that with data, looking at a prescriber's practices before or after or practices, that correlate with the remuneration to make assertions about causation. And of course, whether you have the certifications or not depends on what type of claim you're talking about. But most claims to federal healthcare programs require express or implied certifications of compliance with the AKS. And so I would always plead this both ways.
Tejinder, we got a circuit split here. What's the chance that this ultimately could land at the Supreme Court?
There is a split. It's what we would call in Supreme Court practice a shallow split. The split is 3-1 right now, where the Third Circuit hasn't come back to its holding in a little while. I would say that if more courts join the Third Circuit side, I would certainly expect defendants to want to take this issue up to the Supreme Court in those cases. And I think if the split becomes 3-2 or deeper, that the court would be likely to take on the case. If the split stays shallow, that is, the majority of circuits just continue to follow the 3 circuits that have said you need but for causation, then I would expect Supreme Court review to be pretty unlikely unless you get like a really big case out of the Third Circuit. Another factor that I think blunts the likelihood of Supreme Court review a little bit is that even though the but-for causation standard applies to this AKS amendment, there remains the side door of the certification claims that we've talked about. And so it's not immediately clear how much of a practical difference this is going to make in cases if you have that certification theory properly preserved.
Tejinder, thank you. And thanks to each of you for joining us for this episode of the Federal Bar Association Key Sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.